The certified letter arrived on a Tuesday, nestled amidst junk mail and credit card offers, its heavy bond paper and official-looking seal giving it an air of importance that was immediately undermined by the sender's address, the Preserve at Whispering Pines Homeowners Association. Liam O'Connell, a pragmatic software engineer who valued his peace and quiet above most things, plucked it from the stack, his brow furrowing. He had lived in his charming, slightly rustic, yet impeccably maintained home for 5 years, a home situated on a small, isolated cul-de-sac that abutted the larger, newer subdivision known as the Preserve. The crucial point, the one Liam thought was abundantly clear, was that his property, by virtue of its original plat and deed restrictions, was not part of the Preserve at Whispering Pines HOA. He deconfirmed this with title work, county records, and a brief, civil conversation with the initial developer. He had intentionally chosen his lot for its tranquility and freedom from restrictive covenants. He tore open the envelope. The letter, penned in an aggressively formal font, was a summons and complaint, demanding his appearance in small claims court. The plaintiff was listed as the HOA, represented by its president, a woman whose name, Brenda Albright, was quickly becoming synonymous in Liam's mind with high-pitched, self-righteous indignation. The basis for the lawsuit was startlingly simple. The HOA was asserting that Liam's property fell within the implied geographical boundaries of the subdivision and that, by refusing to pay dues for the last 5 years, he owed them approximately $10,000 in back fees, penalties, and accrued interest. Furthermore, the complaint alleged that his lack of adherence to their aesthetic standards, specifically mentioning his choice of a darker, heritage green mailbox and the placement of his compost bin, was detrimental to the overall property values of the Preserve. Liam felt a slow, simmering heat rise in his chest. It wasn't just the ludicrous monetary demand, it was the sheer, audacious nerve of the claim. Liam put aside his work for the rest of the afternoon and dug back into the paperwork he thought he'd long since filed away and forgotten. He retrieved the original title insurance documents, the survey maps, the deed itself, and the legal description of the property. He cross-referenced all of this with the official plat map filed with the county clerk's office for the Preserve at Whispering Pines. The evidence was irrefutable, printed in thick, black lines and precise metes and bounds. His property was clearly and unequivocally marked outside the boundaries of the HOA jurisdiction. The cul-de-sac he lived on was designated as an independent, private road access, intentionally omitted from the HOA's purview during the initial development phase. The more he looked at the lawsuit, the more he understood the tactics at play. This wasn't a good faith legal dispute, it was pure, unadulterated intimidation by a community that believed its own rules transcended actual law and property rights. Brenda Albright, or HOA Karen, as she was known by every local who had ever had the misfortune of dealing with her, wasn't seeking justice, she was seeking control. She likely saw Liam's independent property as an irritating visual flaw in her perfectly organized neighborhood tapestry. Liam realized he could easily file a motion to dismiss with the overwhelming evidence he possessed, which any sane judge would grant immediately. But the thought of simply dismissing the suit and allowing Brenda Albright to continue her reign of terror, perhaps targeting the next person who slightly offended her sense of order, irritated him deeply. He decided a simple dismissal wasn't enough. He wanted to make a point, a very large, public, and legally devastating point. He spent the next few days meticulously organizing his defense, not just as proof that he didn't belong to the HOA, but as an attack on the legitimacy of the lawsuit itself. He highlighted the section of the HOA's own covenants which stated that new properties could only be annexed with the written consent of the owner, consent he had certainly never given. He compiled a detailed timeline of his refusal to pay and the HOA's failure to ever produce a legal document showing jurisdiction. He even took photos of the alleged violations: the well-maintained, aesthetically pleasing green mailbox and the discreetly placed compost bin, to show the subjective and malicious nature of the complaint. When the court date finally arrived, Liam walked into the small claims courtroom feeling calm, prepared, and a little amused. He wore a simple, professional suit and carried a slim leather briefcase holding his ironclad evidence. He saw Brenda Albright immediately, a woman in her late 50s, impeccably dressed in an expensive suit, with a tense, triumphant look on her face. She was flanked not by a professional attorney, as small claims often allows parties to represent themselves, but by two other nervous-looking HOA board members, one carrying a thick binder overflowing with paperwork. Brenda spotted Liam and offered a tight, self-satisfied smile, the kind that suggested she was already mentally spending his $10,000. She was clearly expecting Liam to be intimidated, unprepared, and ready to cave. She had no idea she had just walked into a legal ambush laid by a man who treated legal research like debugging a complicated piece of code, finding every flaw and exploiting every vulnerability. The stage was set for a dramatic, deeply satisfying confrontation that would be about far more than 5 years of unpaid dues. The air in the small claims courtroom was heavy with the low hum of nervous whispers and the shuffling of papers as the clerk called the case: the Preserve at Whispering Pines Homeowners Association versus Liam O'Connell. Brenda Albright, resplendent in her power suit, rose instantly, adjusting the lapels of her jacket with a gesture of authority. She approached the podium designated for the plaintiff, carrying her thick binder like a shield and a weapon. Liam, following her, took his place opposite, setting his slim, organized briefcase neatly on the table. The judge, an experienced, world-weary woman named Judge Eleanor Vance, surveyed the two parties over the rim of her reading glasses, a familiar look of skepticism already present on her face. She had seen countless HOA disputes, but the sheer size of the claim for a small claims setting suggested this one might hold a special kind of absurdity. Brenda began her presentation with a theatrical flourish, speaking in a loud, clear voice designed to command the courtroom. She launched into a detailed, yet largely irrelevant, history of the Preserve, emphasizing its commitment to harmonious aesthetic standards and preserving property values. She then pivoted to Liam, accusing him of being a free rider who benefited from the HOA's neighborhood amenities and maintenance: the common lighting, the entrance landscaping, while willfully neglecting his financial responsibility. She pointed dramatically to the complaint, reiterating the demand for the $10,000 in back dues and penalties. Her argument rested entirely on the notion that Liam's property, situated as it was directly adjacent to the neighborhood's main entrance, was an organic extension of the community and therefore subject to their rules, even without a specific deed restriction. He cannot simply declare himself exempt, Your Honor, she finished, her voice rising to an indignant pitch, when his actions, his green mailbox, his unscreened compost bin, directly impact our established community image. When it was Liam's turn to speak, he did not try to match Brenda's volume or theatrics. He approached the podium with calm professionalism, his voice measured and clear. Your Honor, with all due respect to the plaintiff's passionate defense of their mailbox color palette, Liam began, earning a subtle, almost imperceptible straightening of Judge Vance's posture. The issue here is not aesthetics, it is basic property law and jurisdiction. The plaintiff's claim is fundamentally and legally impossible. He didn't bother to deny the benefits, he cut straight to the core legal issue. He then opened his slim briefcase and pulled out 3 highly organized, tabbed documents. I submit Exhibit A, Your Honor, he said, handing the documents to the bailiff for the judge's review. This is the original recorded plat map for the Preserve at Whispering Pines, certified by the county clerk. You can clearly see the legal boundary line, marked in red. My property, parcel 14B, is located outside this line. I also submit Exhibit B, which is my own certified deed, which contains no reference to the covenants of the plaintiff's HOA. He paused, letting the judge examine the documents. Judge Vance, whose expression had remained neutral during Brenda's tirade, began to read the documents with focused attention. Brenda, sitting at the plaintiff's table, suddenly leaned forward, a furious whisper escaping her lips. "That's irrelevant. We sent him revised documents." Liam ignored her, waiting until the judge looked up. "And finally, Your Honor, Exhibit C is a copy of the plaintiff's own covenants, conditions, and restrictions, specifically Article 9, Section 2, which states that any property outside the original plat may only be annexed upon a 2/3 vote of the current members and the express, written consent of the owner. I have never been asked for, nor have I ever granted, any such consent." Liam folded his hands and looked squarely at the judge. "The plaintiff is suing me for violating the rules of a club I never joined, based on a geographical boundary they have unilaterally, and unlawfully, decided to redraw." The courtroom suddenly felt very, very quiet. Judge Vance slowly laid the documents down. She glanced from the clear property lines on the plat map to the specific language in the HOA's own covenants. Her gaze then swung to Brenda Albright, who was now flushed crimson, frantically whispering to her silent board members. "Ms. Albright," Judge Vance said, her voice low and heavy, "Mr. O'Connell's evidence, specifically your own recorded covenants and the county plat map, appears to be quite definitive. Can you offer any legal basis, any recorded amendment or annexation document, that places parcel 14B under your jurisdiction?" Brenda scrambled for a moment, pulling out a poorly copied sheet from her monstrous binder. "Your Honor, this is a resolution passed by the board unanimously to annex the property based on its natural proximity and the fact that we maintain the landscape leading up to his cul-de-sac. It's a matter of equity." Judge Vance didn't even pick up the paper. She pointed to Liam's Exhibit C. "Ms. Albright, your own governing document requires written consent of the owner. You don't have that, do you?" Brenda hesitated, then mumbled, "No, Your Honor, but nothing," the judge interrupted, her patience visibly thinning. "You are wasting this court's time and harassing this homeowner with an unfounded, baseless lawsuit that directly contradicts your own recorded legal instruments. Furthermore, you are seeking to enforce covenants on a party who has no legal obligation to you." Judge Vance leaned back, her eyes narrowing as she studied the sheer size of the HOA's document binder. "How many properties are currently under the jurisdiction of the preserve at Whispering Pines HOA?" Brenda, completely deflated, whispered, 98, Your Honor." The judge nodded slowly, considering the implications of an organization that so casually ignored its own foundational documents. The case was quickly approaching a climax far more devastating than a simple dismissal. The atmosphere in the courtroom had shifted from tension to a heavy, almost breathless anticipation. Judge Vance's final question to Brenda Albright regarding the total number of properties was not a casual inquiry, it was the prelude to an impending judgment far more sweeping than either party had anticipated. Brenda's weak admission that she lacked the necessary written consent from Liam, coupled with her previous insistence that a simple board resolution could override their own legal framework, had profoundly irritated the judge. Judge Vance was clearly not just looking at a misguided civil case, but at an HOA that operated with an alarming disregard for its own founding principles and the very rule of law it relied upon for its existence. The judge leaned forward, fixing Brenda with a gaze that brooked no further evasion. "Ms. Albright, If your board can unilaterally decide to annex properties outside the original plat map without following the requirements of your own legally binding covenants, conditions, and restrictions, what other fundamental governing rules have you decided are merely optional? She paused, allowing the question to hang in the air, a massive, unanswerable accusation. The legitimacy of a homeowners association, particularly its power to levy fees and enforce restrictions, is derived entirely from the strict adherence to its governing documents. If you treat Article 9, Section 2, which deals with the expansion of your jurisdiction, as a suggestion, what confidence does this court have in your adherence to any other article, such as the ones that establish your annual budgeting, election procedures, or even the initial creation of the association itself? Brenda's face was a mask of panic. She sputtered, attempting to defend their actions by claiming necessity and the desire to protect the community investment, but the judge cut her off with a sharp, decisive wave of her hand. The law is not based on the perceived necessity of a three-person board, Ms. Albright, it is based on the documents you filed with this county. And those documents clearly state how you expand your boundaries, a procedure you have unequivocally ignored in attempting to sue Mr. O'Connell. Judge Vance then turned her attention to the thick, multi-volume binder of regulations that the HOA representatives had brought, its sheer bulk now seeming less impressive and more like evidence of overreach. Based on the plaintiff's own presentation and documented failures to follow their most basic governing protocols, the court must now question whether the Preserve at Whispering Pines Homeowners Association is operating under valid legal authority at all. Liam, watching this legal dismantling unfold, felt a surge of professional admiration for the judge's acuity. He had come to the courthouse merely to defend his property rights. The judge was seizing the opportunity to defend the integrity of property law itself. This wasn't just about his green mailbox anymore. Judge Vance asked the HOA board members present if they had brought a copy of the original Articles of Incorporation and the original Master Declaration establishing the HOA. They exchanged nervous glances. Brenda admitted they had only brought the most recent, amended versions. Unacceptable, the judge stated flatly. The very document you rely upon for the right to sue a man for $10,000, you failed to bring. However, she added, turning to the court clerk, the court will take judicial notice of the public record. She instructed the clerk to quickly pull the county records for the original 1998 declaration establishing the Preserve at Whispering Pines. Within minutes, the clerk returned with a printout of the founding documents. The judge studied them for a long moment, her eyes scanning the precise legal language of the initial creation. She found what she was looking for in the very first article detailing the structure and lifespan of the association. She looked up, the finality in her expression absolute. It appears, Ms. Albright, that your association, founded in 1998, included a clause common in initial developer setups, establishing an initial term of 25 years, subject to a supermajority vote for re-establishment. She looked down at the calendar on her desk. 2023. This is 2025. That initial term expired 2 years ago. Do you have on file, and can you provide immediately, the recorded evidence that the Preserve at Whispering Pines HOA was legally re-established by the requisite supermajority vote prior to the expiration date? Brenda was silent. She frantically riffled through her binder, the papers shaking violently in her hands, her face now completely white. After a strained, agonizing minute, she looked up, her voice a defeated whisper. Your Honor, we never held a vote. We assumed it was perpetual. The board simply continued operating. You assumed, Judge Vance repeated, allowing the weight of the word to crush the plaintiff's case entirely. She then looked directly at Liam, nodding slowly. Mr. O'Connell, You were correct to note the plaintiff's disregard for their own governing documents. In fact, their disregard appears to be total. The judge turned back to the court recorder, her voice now sharp and official, delivering the sentence that would send shockwaves through the entire subdivision. The complaint filed by the Preserve at Whispering Pines Homeowners Association against Liam O'Connell is hereby dismissed with prejudice. Furthermore, based on the plaintiff's own admissions in court regarding the lapse of their foundational declaration and their failure to legally re-establish the entity as required by their original governing documents, the court finds that the Preserve at Whispering Pines Homeowners Association is not currently a legally recognized, operative entity with the authority to sue, levy fees, or enforce covenants in this county. Therefore, the court orders the immediate dissolution of the Preserve at Whispering Pines Homeowners Association. All recorded covenants are hereby nullified, effective immediately. The gavel came down with 3 final, thunderous strikes, signaling the stunning, instant collapse of Brenda Albright's petty reign and the liberation of 98 homeowners from a legal entity that had failed to even legally exist.